So, you're in a dispute at the Strata Management Tribunal, and you were really hoping for a quick, clean settlement. But what happens if that just doesn't work out? When negotiations break down, it can feel like you've completely hit a dead end. Well, in this explainer, we're going to pull back the curtain on the crucial next step in the process, so you know exactly what to expect.
You've been to the tribunal, you've tried to negotiate, try to find that common ground. But nope, it's just not happening. You're at a total impasse. And that's a really frustrating place to be. The big question looming over you is this one. What happens now? Is the whole thing just stuck?
And here's the good news. The answer is no. The process is specifically designed not to stop here. There is a clear official path forward. Your case doesn't just fall into some legal black hole. A specific rule kicks in to make sure your dispute gets the formal hearing it deserves. And that rule, the one that saves the day, is Regulation 21 of the Strata Management Tribunal Regulations from 2015. You can think of it as the legal mechanism that automatically gets triggered when mediation fails. Its entire job is to guarantee the process moves forward to a proper hearing.
Okay, let's look at the exact legal text here because the wording is so important. It says, if you can't reach a settlement, the secretary shall issue a notice of hearing. Now that word shall is absolutely key in legal language. It's not may, it's not could, it means they must do it. It's a command, not a suggestion.
Let's break that down into 3 simple steps. Step 1, your settlement talks officially fail. Step 2, this failure acts like a trigger, forcing the tribunal secretary to take action. And step 3, the secretary then issues that super important document, the notice of hearing. See? It's a clear, straightforward process.
So what is this Form 4 that the regulation mentioned? Well, think of it as your official summons. It's the legal document that formally calls both you and the other party to a full-blown hearing before the tribunal. The moment you get this, you know your case is officially on the schedule.
All right, so you know a hearing is definitely coming. But the next logical questions are, of course, when is it going to be and where? Well, the second part of Regulation 21 has got us covered.
And here it is, the next piece of the puzzle. Again, the language is very precise. The secretary is the one responsible for locking in all the essential details, and then the tribunal itself communicates them to you. This makes sure all the logistics are handled officially and nobody's left guessing.
So to put it simply, you will be officially notified of 3 critical things: the exact date of your hearing, the place or location where you need to be, and the specific time it all kicks off. There's no guesswork involved here. It's all going to be formally sent to you.
Now, you might have spotted that phrase reasonable time and are wondering, okay, but what does that actually mean? And that's a great question. The law doesn't spell it out in a specific number of days or weeks, but what it does is create a legal obligation for the tribunal to act without any huge, unnecessary delays. It's there to keep your case moving forward.
Okay, let's pull all this together and talk about the big picture. Why is this one regulation so important? Honestly, it's not just about paperwork and timelines. It's about protecting your fundamental right to have your case properly heard and decided on.
I mean, just look at the difference this regulation makes. Without it, a failed settlement could just leave your case floating in limbo, with total uncertainty about what's next. But with Regulation 21, you have a guaranteed hearing and a crystal clear path forward. It creates certainty right when things feel the most uncertain.
So if you only take one thing away from this whole explainer, let it be this. Regulation 21 is your safety net. It's the legal guarantee that no matter what happens during those settlement talks, your case will get its day in front of the tribunal.
So there you have it. Regulation 21 gets you that notice and sets the path forward to a hearing. But that, of course, leads to the next massive question, doesn't it? Now that you have that hearing date on the calendar, are you truly ready to stand up and present your case?